Now, one person we did hear from today for the first time, Karen Reed herself, doubling down, of course, saying she did not do this. She wants to know who did.
Said it feels we're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life.
Yeah.
I tried to save his life at 6 in the morning. I was covered in the only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times she admitted to it.
No, she didn't.
That's not true.
She asked a question. She asked a question, which is very different. She didn't admit to anything.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record. Okay. How is everybody? Hello, holistic psychology. Hello, Manuna? How do you pronounce your name? Hello, Maestro, Tanja, Tammie, B-Rabbit. Hello, everybody. Wanted to talk about Karen Reed's hearing today, which got quite lit. Jackson went for the full spontaneous combustion. Hey, Jeffrey. Move. And what it really points at is when you have a weak argument, add a lot of theatrics. So they didn't ask to preserve this evidence. So last time we were maybe time before last, a couple times ago, we were talking about their motion to get thousands of dollars for an expert they sent to the Canton Police Department to get video that didn't exist. And they want to get reimbursed for everything, including the snacks that the guy ate at the airport, their expert ate at the airport. $12,000 and change. And it went further today when they just want not only the money, but they want it to be seen, the defense does, Alan Jackson, as a kind of sanctions. But not to bury the lead, we started the hearing off with one of the truly awful judge's decisions I've ever seen in my career looking at true crime trials, with Judge Cannoni approving McNasty Green as an expert, even though his opinions are so thoroughly debunked by modern forensic science that they had to rewrite the entire Cellbrite program so errors like his would not be made. And so if this gets approved, then why not have a flat earther come in and try to convince the jury the earth is flat? This is an absolutely absurd ruling. I knew it was coming in. It's as I predicted. I knew she was going to bring it in, because if you don't bring in McNasty Green, it reflects badly on her. Well, why was he okay as an expert in the first trial and not the second trial? You saying that you were allowing experts who weren't up to snuff who were going to testify about science that is thoroughly so debunked that they had to change the whole program. So I think this is one of the truly terrible judges' rulings. And on Saturday, I'm going to have defense lawyer David McKenzie on with me to talk about truly terrible rulings, and also to talk about innocence fraud campaigns and how to vigorously, he's a defense lawyer from Oklahoma. He's won more awards and accolades, my Lord. And he's had a long career as a defense lawyer in Oklahoma, some very high profile cases, Julius Jones for one. And he's going to talk about how to defend your client vigorously without going beyond the confines of the law, and how you deal with, just as a lawyer in general, terrible terrible judges' rulings. Because for the defense, they always can appeal after the verdict. The prosecution, there's no appealing on after the verdict. They don't get if Karen Read gets acquitted. And the more this goes on, the more I think we're headed to another hung jury in this trial. And when I hear that there's no discussion yet about sequestering the jury, this innocence fraud campaign is so extensive. I get that they're trying to get a broad cross-section of people in as jurors. But we already know that one free Karen Reader got on the jury last time. I think more than one. I think the two holdouts were free Karen Readers. That's just my opinion. It's a hunch, only to be taken with a pinch of salt, not a fact. So here we go. Let's take a look at the hearing today, and I'll circle back. Also, before I begin, Lindsay really needs your help. She has been a victim of a smear campaign. If you haven't been a victim of a smear campaign before, you're lucky. It's really one of the most stressful things to go through. And she needs a lawyer to help fight her case against Aiden Turtleboy Carney. She needs a lawyer to represent her. She's being sued for $2 million. So there is the GoFundMe. Please, even if you have $5, $10, I know everybody has $5, even at their brokest, to spend. Shoot it over to Lindsay. She really needs the help. The link is also in the description of this episode. Okay, here we go. Here's the hearing.
All right, so to start, I'm going to start with the Commonwealth's motion to exclude defense witness Richard Green's debunked opinion.
So, Tammie, thank you for sharing the link. Right, share the link. That's another thing you can do. Share the link. Send her some do-re-mi. Share the link. But even people on this side of the fence are really letting Lindsay down, so she really does need our help. Let's get her to her goal of $10,000. It's not a lot of money in the grand scheme of the entirety of all of us together. I think we can get it done. And I donated as well.
So after review of the pleadings, it's clear to me that the issues that give rise to the dispute do not invoke the gatekeeper function of the court. To me, it's rather a difference of opinions that need to be resolved by the jury. So I'm denying your motion. I'm not going to exclude the evidence.
It's not evidence. It's literally debunked opinion. It's literally not based on anything. It's wrong. I'm going to allow him to share his wrong opinion. It's not a matter of opinion. It's been proved wrong, so much so that the software company had to change the software. Come on. What else can we say that? Can I have an expert that says that gravity pulls us upward? I mean, what? I mean, what else? Terrible ruling. Terrible.
All right. So then
and it's only really hurting Karen Reed. Karen Reed needs to have better experts than this. She wants to fight her case, but she's gone the route of total fantasy. So she's not exploiting, say, weaknesses in the state's case as much as she is putting on a figment fantasy defense out of the figments of her imagination. I don't think that the last jury bought that Jen McCabe and the McAlberts are killers any more than the next jury is going to decide that. But I do think we may be heading towards another hung jury with these bad judges' decisions. The idea in the second trial is to clean up anything that could possibly confuse a juror and get another hung jury. And that does not seem to be happening here. Marie Russell's coming in, totally unqualified expert as well. But this is a terrible ruling by Judge Cannoni, who I feel is very pro-defense.
what I'd like to move to is the defendant's motion to recover expert-related expenses from the Commonwealth. I did get a response from the Commonwealth on this, so I need to hear, Mr. Jackson, what it is you're asking me to do and why.
The court did receive the addendum filing the court asked for as well, correct?
No, because I've been waiting for it and I do not have it, and I checked as recently as 5 o'clock yesterday and this morning.
I'll get it.
Okay. Do you have an extra copy if you want me? Because I don't.
It was coming from, the final copy was coming from Miss Little from back in my office. That was.
When did she send it?
Yeah, speaking of Miss Little, where is Melanie Little? I'm sorry, Elizabeth Little. Melanie Little. We all know where Melanie Little is. She's putting out her skincare secrets and getting affiliate links from her Amazon on the cream she uses. So the hearing starts out with Alan Jackson screaming about how Karen Reed's rights have been denied. This is really not so much for the money they're owed to get back that, but to really, although that would be nice, Karen Reed is frugal, as she called John O'Keefe. That's my opinion. I have a hint of a suspicion that she might be frugal and doesn't want to pay anymore for her defense. But where is Elizabeth Little? She's MIA. She's back in the office. Are we going to see her at trial? Is it going to be just like a huge defense table with Robert Alessi, Elizabeth Little at all?
I'll check it. Yeah, no, Judge reminds me, I did get something else, but it wasn't Chris.
It was from the Commonwealth, so I've been waiting for this, so I need a minute
That was
to
sent
read
at
it.
12:57 p.m. yesterday.
I did not get it.
No.
So they also have the feeling of, the defense does, of kids who haven't done their homework, who are behind in the class, who have been goofing off, because they keep promising their motion to dismiss the whole case and begging the judge for weekends and more time. And they're not sure on what grounds they're even going to do it. And this, I felt, was a lot of bluster and I thought Hank Brennan, it was hard to argue with when Hank Brennan. So when you listen to Alan Jackson, you think this is the greatest Brady violation that's ever been. But take a listen. Are we still watching Judge Cannone read it? Wow, that took a
This
while.
court maintains the inherent authority to issue sanctions when there is an injustice. And those sanctions can include something like cost-shifting sanctions.
Right. We want the court to be sanctioned, meaning we want punishment for the Commonwealth not preserving this evidence of the Sallyport video of the car coming in, because it's, according to the defense, which is untrue, that it's the only evidence of the car's condition before it got in the hands of the police. It's not true. There's the footage from John O'Keefe's driveway that morning, 5:07. There it is. There's the oh no, it's a little later. There's Karen going away, and then the welfare check, which happened later that morning. Excuse me.
Sanctions. And there's a body of law that exists that deals with this exact thing. And that body of law includes the case of the Committee for Public Counsel Services versus the Attorney General. That's at 480 Mass 700. It's a 2018 case. The court may remember what was, I think, pretty widely known here in these parts, which was the Amherst scandal. Had a bunch of cases going back from 2010 all the way through.
I'm very familiar with the case.
All the way through 2018, and it culminated with Justice Gaziano discussing in his opinion, single justice opinion, exactly.
8:22. Excuse me. Excuse me. I mean, to say that's the only video of. They just desperately want Karen Reed to get her money back for this waste of money. When Hank Brennan will come tell everybody, like, hey, guys, I told you that they might not have it. You're welcome to bring an expert. And apparently they were going to bring some other expert, and they changed their mind and switched him out at the last minute, sent someone else. They said, we're going to bring Joe Schmo, and Tim Schmidt showed up as the expert. Like, what's going on in the Free Karen Reed defense?
These types of things. And what Justice Gaziano said was, quote, the Attorney General does not dispute that the court has the authority pursuant to Rule 14, sub C, sub 1, to impose remedial monetary sanctions for a discovery violation. And he cites Commonwealth v. Firth, indicating that sanctions may be imposed under Rule 14 for failure to comply with discovery obligations, and sanctions should be tailored appropriately to cure any injustice resulting from a party's non-compliance with its discovery obligations. So the real question before the court today is, and really the only question before the court today is, has Ms. Reed suffered any prejudice?
Has she suffered any prejudice? So Yannetti said that all evidence must be preserved, but you have to be really specific. All video evidence, all this kind of physical evidence. You can't just say all evidence needs to be preserved, because then you get into what's considered evidence. And certainly much of the Sallyport video was preserved, but obviously not the part they're looking for. Cat in the Hat says Karen Reed does not want to dip into her own money. John's life meant nothing to her, and defending herself in his murder using her money is not an option in her mind. True. Right on the money. No pun intended, Kat. You got it.
Based on blatant discovery and Brady violations by the Commonwealth? And the answer to that question is a resounding yes, she has. Your Honor, Ms. Reed, as the court knows, is on trial for her life, and she's been expending precious resources for some 3 years now, defending herself against provably false allegations. And at the center of that storm of defense are these Sallyport videos. It should be pretty straightforward, really. I mean, it's just a series of videos at a particular location for a particular time. And that time is January 29th, 2022, from midnight until 11:59. It's 24-hour period, 23 hours and 59 minutes. Should be pretty simple, but it has been anything but simple in this case. We've been asking for a full download of every single one of those cameras and all that footage from January 29th, 2022, from 12 a.m. to 11:59, but we've never gotten it.
When did you first seek it?
We asked for the preservation on February 2nd, 2022, when Mr. Yannetti said retain and maintain all physical evidence. We've been seeking these videos since well before.
Right, but you could argue physical evidence is not video evidence. You have to be really specific. They know this. They're lawyers. And spoiler alert, as everyone's writing the comments, judge denied it. Thankfully. Thankfully. But watch him get really almost spontaneously combust.
The first trial. We didn't get them before the first trial.
Do you have a date? Do you have any chronology for me?
I don't. I can certainly provide those, but it's been...
I'd like that. I mean, that would be helpful.
I'll be happy to do that. It's in discovery request after discovery request after discovery request.
Also, what I think this paints at is the beginning of Alan Jackson and David and Hank Brennan, excuse me. Alan Jackson and Hank Brennan really starting to not like each other. And a lot of times there's a lot of acting going on in these hearings. I think we're going to see more of this pushback against each other, this kind of fighting in the trial between Hank Brennan and Alan Jackson. Hank Brennan has said that he has a very broad idea of discovery, meaning anything that he thinks might be at all relevant or not to the case, anything he gets, he hands over to the defense, even if he doesn't have to, like anonymous communications from rando people who watched the first trial. And if you send Hank Brennan an email, it's going to be handed over to the defense. Be fair warned.
Basically, there's also a catch-all. We've been asking.
So my point was that when Alan Jackson, when Hank Brennan said, sure, check, see what's there. I'm not sure it's all preserved, but come have an expert look at it. And went through the trouble of having a guy never heard of, go into the Canton Police Department. Alan Jackson, to try to get sanctions against him, you seemed genuinely teed off at this motion.
For all physical evidence concerning video footage from Canton PD from well before the trial. We didn't specify which cameras because we didn't know which cameras had video footage. We didn't know how many cameras there were, but we didn't.
But they didn't specify video footage at all.
Didn't get anything from the Commonwealth, and I'll address that in particular in just a second.
All right, I'm going to move forward to Hank Brennan. So you get the idea. He's about to spontaneously combust. For the purposes of time, I'm going to move to Hank Brennan's answer.
It's notable that the defense purposely conflates two very separate issues. If you had a chance to read their motion, they suggest that they should receive costs because they hired an expert, came to Canton, and didn't receive the information they wanted. Yet today in the argument, they try to give you a historical complaint about the production of videos in this case. That is a separate issue. That's a Rule 14 issue, but that is not the motion before the court. The reason I suggest they conflate the issues is because they know their merit for costs. I mean, their motion for costs has no merit whatsoever. And so what they're trying to do is incite facts, invoke this injustice they've created so that the court looks at the motion that they actually filed and gets it distorted. It is disappointing to stand before a court and file an affidavit as an attorney and have someone else have a cross affidavit. Frankly, in my career, when that has happened on rare occasions, I find that embarrassing. There is very skilled and able attorneys in this courtroom, and to work out discovery matters and agreements is something that attorneys always should do. And that is what I've tried to do in this case. I have tried to give the defense the best opportunity I can to get whatever information they want, whether it is required or not required.
I've tried to work with Alan Jackson, but unfortunately, Karen Reed's and Alan Jackson seem to be two psychopathic characters in a pod. I cannot work with them. T. Gray put it perfectly. Jackson grandstanding and playing to the Free Karen Reed fools, in my opinion. Yes, you got it.
Yet, I'm standing here today, and I have to now share with you my conversations with the defense. I have to share with the court my position, which is contrary to the defense, because they have lodged a motion asking for money that they are not entitled to. If I stand back and do nothing and remain the dignity of the court, then what happens is there are claims that just float out in nowhere, and a lie unchecked becomes the truth. So now I must stand before you, and I must tell you what happened. When I entered this case in September, and I began to look at discovery, I saw a video produced in August from the Canton Police Department, and we immediately turned it over to the defense. I began a study of the case and tried to articulate and account for all evidence and make sure the defense...
Kitaver William Reed is back in court. The doppelganger for Mr. Burns from The Simpsons, right behind Hank Brennan.
Obtained everything that they were entitled to and more. The defense asked me to try to account for the video because they believed it had been an issue in this case. I looked through the docket. There was no motion to preserve videotape. I read the pleadings. Attorney Yannetti was meticulous in his motions to preserve. It was admirable. It was meticulous, the work he did. There was no motion to preserve, and that has some import.
I love when the Free Karen Reed people call Hank Brennan a creepy mob lawyer. Have you taken a look at David Yannetti's client list and his cases? Because they're all listed. Child essayists, thieves. Alan Jackson, the same thing. What are we talking about here? People prey on other people, prey on children. I mean, defending Whitey Bulger looks like that makes it look like a gentleman compared to the clients of Alan Jackson, David Yannetti.
It doesn't relieve the government of their obligation to provide Rule 14 discovery or exculpatory evidence or Brady evidence. It doesn't relieve the Commonwealth of their obligations to be dutiful, but it is difference in kind. Because the defense, if they want something that is not obvious, they put the Commonwealth on notice. Having practiced for almost 3 decades, you file motions to preserve within 24 hours, 48 hours, or 30 days. And so when Mr. Jackson called me, Attorney Jackson called me, and he said he wanted to come out and bring an expert to look at the NVR or DVR of the Canton Police Department, I had never seen that in 30 years. It's not part of our obligations. He's not entitled to come into the Canton Police Department with his own experts and download his request. But in the spirit of transparency and an effort to help the defense so there will be a fair trial and they can obtain all the discovery, understanding the history of this case, seeing that there was an August videotape post-trial, I wanted to do what I could to accommodate them. So without any hesitation, despite that there was no court order, no motion to preserve, I invited him to come to the Canton Police Department. I called the chief of police. I asked the chief of police, although this was unique and novel, unprecedented, could the defense come and access their material? Typically, the Commonwealth will download it and provide them a copy. She had no hesitation. So I called Attorney Jackson back, and I said that we would allow it. Attorney Jackson expressed concern, understandably, being a defense attorney, that almost 3 years later, the video may not be on the NVR. I had the same concern. I want all of the evidence. I'm not looking for evidence that's good for the Commonwealth or helpful for my case. I want all of the evidence. And so after he expressed the concern, I made clear I had no idea what, if anything, was on the NVR. We could go and look at it, but Mr. Attorney Jackson didn't want that. He wanted his expert to be the person to open the NVR. And respecting his position, providing a...
Which was curious to me, because do you remember in the earlier hearings when Hank Brennan was remarking on how they didn't fully extract the vehicle data very well because the defense, Karen Reed's vehicle data, because the defense was basically running the show? Isn't it curious, once again, that the defense wanted to take control and download everything without the, say, help of the Commonwealth? Just let us into the police department. We'll get it. And they got an incomplete extraction from Karen Reed's car data, strangely. And that's the car data that we've seen. The new car data is out. What's on that is anyone's guess. Also, what was approved today at this hearing was Karen Reed's data on her phone, what she searched, where it shows that she went on her phone. All that is going to could be very compelling evidence when matched with the car data and the other evidence in the case. So the walls are closing in on Karen Reed. If it's useful, if any of this is useful, and what I think Hank Brennan may do a little bit better than Lally, is to put a lot of complicated pieces of evidence together in a clear way that the jury can comprehend and doesn't tune out. Because there certainly was a lot of compelling evidence presented at the first trial. However, it often felt like a mystery sometimes. So Lally would bring up a piece of evidence like the garage door, and it was like, what's the meaning of that not fully closing and not fully being closed? And I never knew exactly what he was trying to prove with that garage door not being fully closed.
Professional courtesy, I agreed. Didn't mislead him. I didn't think there would be video. I had no idea. So Mr. Jackson, Attorney Jackson, pardon me, sent out his expert. And by the way, the expert that came was not the expert they designated. I got a call because we were in court on a hearing that they had sent a different expert they hadn't noticed. And my response was, it doesn't matter. Whoever they send, let them look at it. And so when they did, not surprisingly, the information had been overwritten. Now, while there was a 30-day override on that machine, I believe the defense expert knows that there was a backup hard drive which kept materials longer than that 30 days.
Right. So the one of the defense's arguments in their filing was like, hey, we've gotten things that were later than 30 days. So they knew the hard drive exists. It's not going to all exist. And if the Commonwealth argued this, I can see the defense arguing, well, why didn't they ask for it the first time around? Now they want it? Why now?
I do know that there was materials on that DVR, MVR, back in July of 2024, and I know that from a report that was generated by the Commonwealth and given to the defense, so they should know that as well. That may be one reason why they wanted to come out. They came out on their own volition. I extended the courtesy as much as I could, made no promises. I was clear I was very uncertain about what would be on there since I never looked at it. After I learned there was no information on the NVR, I took the initiative and went to the police department. I viewed the police department, the cameras, I spoke to personnel, and I spoke to the retired individual who then was responsible for providing video upon request. And when I spoke to him, he told me in conversation that he would routinely store a copy on a file he noted as a detective file or on his hard drive. That was news to me. I thought that was helpful, so I notified the defense about my conversation. I was not trying to lure them back to Canton or have them spend money. I was trying to, as I always do, be as transparent as I could and as helpful as I could. Now, what I simply should have done and could have done is I could have gone to that detective file and downloaded the video and given a copy to the defense. That's my obligation, no more. But I didn't. I extended the courtesy that if they wanted to come and look at that file before we opened it, so it could be beyond reproach, they were invited to do that. I wasn't encouraging or luring them. I was inviting them. Because they had already been part of the process, I thought it would be disingenuous not to let them participate. And what they told me is to wait. So now that information, whatever it is, I don't know because I haven't seen it. And I've asked the detective or the retired detective not to access it. It is sitting in that file, supposedly. So at this point, it's the Commonwealth's position that we are going to go and download that information to give a copy to the defense. The defense waited almost 3 years. The defense was very clear about my uncertainty would be on that tape. And now they stand before the court and they try to parlay this into some type of injustice for their cause. The case they cite.
Yeah, welcome to defense attorneys. Every motion has been argued that way. It would be an injustice if McNasty Green doesn't get to give his wrong opinions and confuse a jury. It would be an injustice to Karen Reed to not have a attention-seeking, true crime fan, retired ER doctor cosplay as a dog bite expert, as a defense witness in this case. It would be a violation of Karen Reed's right. It was a violation of Karen Reed's rights that this video didn't exist, that we didn't ask to preserve 3 years ago and we didn't think about, and now all of a sudden we desperately want.
Commonwealth v. Frith. The district court was overruled in assessing costs because there was no egregious violation. This is not a Brady case. This is not a setup. This is the government providing information as the case progresses and evolves and changes and retools. So what we have now is information, supposedly, on a database that we are going to get and give to the defense. You should deny their motion. Nobody was misled in this case. They've taken a professional courtesy and an effort to help, and they've distorted it into some type of injustice. The Commonwealth's not going to be distracted from the cause in this case, which is a trial on April 1st. The court should not be distracted from the cause in this case. If they have a separate motion about Rule 14 violations, or motion dismissed for misconduct, that's a separate motion. That's not the motion before the court today. The motion before the court today is to attempt to recover costs for something they chose to do and that I accommodated.
Right, for money that they burned. Karen Reed being frugal.
It should be rejected. Thank you.
So then Alan Jackson comes back and has a conniption fit. Let's watch some of that.
You're talking about?
The latest one, right. So my request to come out and have an expert come out and see it. That's not just a courtesy. That's just good lawyering on his part and mine. You want to keep your hands clean, let's do it the transparent way. Have everybody come, bring their experts, whoever they might be, and let's download this stuff together. So there's no funny business, and everybody can wipe their hands and say, I didn't have anything to do with it except downloading the material and.
Right, except just like what happened with Karen Reed's car data. There's no funny business there, but strangely, we got an incomplete extraction when the defense was at the helm. It's just good lawyering. He did it because it was in his best interest. Hank Brennan is not going to get caught on a Brady violation or a Rule 14 violation. He's not the one, as the young people say. See, he hands over everything.
Material is, it is. That's just good lawyering. It's not a courtesy. He was doing that to protect his own and the Commonwealth's interests, and it was quite smart. Until he realized, because he didn't have any way of knowing it any more than I did, that there was no footage.
This is Alan Jackson talking to the Free Karen readers. Totally. This is totally about, well, it looks like he's talking to Judge Cannone. He's really talking to the Free Karen readers. You gotta believe me. You gotta believe me. There's been violations here. He's not being fair. He's being smart and strategic and savvy. Tammie, thanks so much. What was the name of the defense attorney you're having on Saturday? I'm having on David McKenzie on Saturday to talk about innocence fraud campaigns, bad judges' rulings, everything from a defense attorney's perspective. So check it out Saturday at 6 p.m. Eastern. Thanks, Tammie. We'll get into the difference between... So the purpose of this is just to kind of do a Hail Mary pass and try to get back the money, because they know Judge Cannone is a soft touch and often goes with the defense and their terrible arguments. Try to get back the money they lost on this adventure. But the more pressing thing is to speak to the Free Karen readers and get them riled up, and also get them emptying their wallets. Karen Reed needs our help. Her rights have been violated. More money for the fight. Help her fight her fight. She's factually innocent. LOL.
It had been overwritten. Perhaps, certainly the defense was deceived. Perhaps Mr. Brennan was deceived as well. He indicates that he contacted Chief Rafferty, and she said, with no hesitation, bring him on out here. I wonder if that lack of hesitation had anything to do with the fact that the chief knew that there was no data on the DVR. You can come look all you want to.
Yes, it did fail watching the whack jobs. Nice to see you. It did fail. I think it gives us an idea of where they're at, though, now, which is always to use these hearings as a kind of Free Karen Reed rally. The motions aren't really so much about what they're about. Sometimes they're about riling up the movement and getting them to feel that something doesn't smell right. The Commonwealth is tricky, unfair, fighting Karen Reed's fight for justice every step of the way with their tunnel vision investigation and terrible bias against Karen Reed, because somehow everyone is against Karen Reed and wants to set her up. Set up the college professor or adjunct professor, whatever, the finance lady, because that's who you want to set up if you're setting up someone for a police officer's murder. I mean, come on.
The bucket's empty. I have no idea about this iCloud account or who owns the iCloud account, why this data on January 29th was moved from the DVR to the iCloud account. Mr. Brennan did say, do you want to have your expert come back out and watch as we download the iCloud account? And I said, let's defer that, because this is literally, these are the contours of motion that's going to be before the court. And I still want to defer it, because what I didn't want to do is pay another $12,000 or $15,000 for a second bite at this apple just to find out that iCloud account is somehow compromised as well.
Can you have someone record it? Can you have somebody that won't cost you $12,000 if you want to come out and just have someone record it as it's being done?
Sure, I didn't mean to interrupt the court. Yes, I can certainly make accommodations other than flying an expert out and having somebody do it in person. That may be an option that we exercise. I may talk to Mr. Brennan about that, because I still want to have some transparency on that process. But what I don't want is to spend...
All right. So you get the idea. It goes on and on and on, angrier and angrier, more explosive.
Absolutely no good reason. I'll submit.
All right. Mr. Brennan, I have just a couple of questions.
Yeah.
So you don't know for certain whether this information was in fact downloaded onto the hard drive, but you suspect it is based on your conversation with the named gentleman in your affidavit?
So there's two different systems. One's called the DVR, NVR. That's the actual system that keeps all the footage that's recorded. That has been searched.
Commonly is overridden every
Yes.
30 days.
Like has been overwritten.
Statewide police departments.
Yes, Your Honor. And
Okay.
that has been overwritten.
Okay.
And there is no information on that.
Okay.
When I spoke to the retired sergeant detective who had downloaded video, he said as a habit, he would routinely, when he would make a video copy from the DVR, he would place it in a separate file. I can't say that it's exhaustive. I can't say that it captures all of the video. It's when he would make a copy, and it seems in this case there were select copies made. It doesn't seem that there was ever a time when somebody just copied the entire event. Now, the issue of whether there was a request for it, the obligation of the Commonwealth, I think it's...
Right. And so this is this what happened with Sergeant Good's cruiser video? And if there is missing video, like, for example, like if you caught yesterday's episode, Jen McCabe in the back of Sergeant Good's cruiser Googling something, why wasn't that preserved by her lawyer, Kevin Reddington? Why wasn't that preserved by the Commonwealth or Karen Reed calling her father, the back of the police cruiser? Why haven't we seen these videos? It's frustrating. When they have such an expensive WatchGuard camera system with state-of-the-art audio, state-of-the-art video, state-of-the-art system. I mean, why haven't we seen any of this stuff?
A separate issue. What exists on his hard drive in the detective file, I don't know. But what he has told me is he would routinely make copies of what he would provide to the court and the Commonwealth, or the Commonwealth and the defense, and he would put on that separate file. I don't expect, and I'm only guessing, that it's going to be an exhaustive copy of the entire night of January 29, 2022. I don't expect that. I expect it will be a copy of whatever it is that he has provided in this case. And so I think before it just lingers there forever, it should be copied and it should be provided to the defense.
All right. So I do want you and Mr. Jackson to talk about whether within the next week you do have somebody video it, or at your expense you send somebody out at it, but let's get moving with that. I know you said you'd make download a copy and send it. Are you satisfied with that, Mr. Jackson, or do you want to have someone there while that occurs?
I at least want to noodle on that for a second, but I'll talk to Mr. Brennan about it.
All right. I'd like it done within the week.
He wants to noodle on it. He wants to take another bite of the apple, and afterwards he wants to noodle on it. What an expression, right? I want to noodle on it. Heisenberg, hey, AJ, what went on with the missed car data? Great question. That's what I want to know. And what's on the car data now? He's got a noodle on it. He might have to noodle on that question, Heisenberg. Thanks so much.
The person has to be there within next week, or the Commonwealth will download it. We've got to get this case moving, and you want it, so it's got to be provided.
The stall isn't my fault. Yes, we want it. That's why we asked for it in the first place.
Yeah, so let's try and work it out before you leave here today, okay?
Sure.
Your Honor, I'm happy to defer the defendant's request. I'm prepared to do it now. If they want me to wait, they want.
Oh, Alan Jackson and Karen Reed are sitting in the same kind of defiant, stubborn child way. And they were caught. Here's Grant Smith Ellis's tweet on it. Just make sure. Yeah, hold on one second. On at Smith and Walensky's very expensive steak restaurant, the bar. Here's Karen Reed's knee. Now the free Karen Readers, because they couldn't say that this was fake too. They all bought that story, that the first video of Alan Jackson with his hand on her breast, grabbing Karen Reed from behind, was fake somehow. They were saying that this is part of the chair where the gray is, but you can see that these chairs have no arms, that's Karen Reed's leg, and there's his elbow right on her knee, getting awfully cozy. And I could tell that there was something going on with Karen Reed and Alan Jackson when Karen Reed started to scream, whisper in a very aggressive manner at Alan Jackson in a way that you don't do with just someone who you're in the polite stage with. That kind of intense fighting speaks to having been very intimate with someone. Hey, Artworks too. Karen doesn't look well. Yeah, things aren't going her way. Artwork. They're not going her way at all. I mean, she has her experts in, but it might have been better for her not to have those experts allowed in, really. Her experts don't make her look credible, her defense look credible. And it's once you lose credibility with a jury, it's not a great thing.
But we're ready to do it now.
All right, so I'm telling you to please wait, work it out, but no later than next week.
I understand.
All right, thank you. Did you want to be heard further? In
Briefly,
response?
Your Honor, although I've come into this case late, I am the Commonwealth, and I assume all responsibilities of the government's case in the history of it. This motion is not about a Rule 14 complaint or a violation. If the defense has a motion to sanctions or to dismiss or whatever the remedy is because they think they've been aggrieved, that would be a different motion. This motion is they're trying to get the court or asking the court to impose costs because they had their expert come out at their request, and they were very clear about the risk associated with that. This motion should be.
Jewelry says, hi, Roberta. Hey, Jewelry. Thank you so much for sharing Lindsay's fundraiser link. It's pinned to the top of the comment section. It's also in the description of this episode if you're listening on podcast. And thank you to everyone who donated or shared. Lindsay is very appreciative. And there's a message from Lindsay to everyone who donated on the Give, Send, Go link. Check that out.
Denied. If there's a separate motion, we'll deal with that when it's filed. If I had known that the defense was going to argue something entirely different, and that is the failure to preserve, I would have made a copy of all Mr. Yannetti's motions and requests, and I would have provided them as an exhibit. But I did not do that because that was not the scope of this motion. This motion should be denied.
Barbara, the trial starting April 1st, April Fool's Day, appropriately. So he's saying, you're basically trying to make a Brady motion, violation motion, and put it in a recover costs motion. And they do that. They also put things about how they're going to have a motion to dismiss the entire case. And we've been waiting and waiting. At the end of this hearing, Alan Jackson is begging for more time for his motions, which is hard to believe. He's had a whole team of people Commonwealth are like 3 people. He has Robert Alessi, it's David Yannetti, Elizabeth Little, Alan Jackson himself, and a whole team of people, I assume, in their office. Why can't he get these motions done on time? So, next hearing is the 18th, I believe. Correct me if I'm wrong. They have a lot of deadlines before that, but they're trying to move things along before the hearing. But denied. That was the name of the game. But it just goes to kind of dirty defense playing. Putting, trying to make it look like the Commonwealth is trying to deny Karen Read her rights when they're really bending over backwards to hand over everything and hide evidence. And all of that is very good for bringing in money for Karen Read. All right, let's get to your comments.
We got your comments. You had something to say. You were insightful. Oh, so clever. So Roberta's going to read your comments. Hey, Roberta, read those comments.
Doreen Perv says, 100%, Roberta, there is only the truth. So this is my criticism of the Fox Nation, is that what it's called? Entertainment piece about Karen Read. And they called the second episode Conflicting Truths. And I said, what's a conflicting truth? There's only the truth. You can have conflicting opinions, but not conflicting truths and conflicting stories. There's only the truth and conflicting stories. Thank you for standing up for the truth. You're welcome, Doreen. Thanks for the nice comment. Jeffrey Kinney says, disagreeing is cool. Being smug, not so much. Refuting her web search is understandable, but it's now up to Jeri. The reason people are using a blanket is because the amount of lies, missing video from library, Sallyport, reverse videos, walking in a snowstorm to move cars, talk on phone, and on, hence why we are not taking you seriously when you're smug. Well, Jeffrey, I didn't think I was particularly smug. And I don't know what you mean if you don't actually point to an example of me being smug or why you took something I said as smug. Using a blanket. I don't know what you mean, using a blanket. Yeah, I said that this is like isn't that weird defense? But tell me who did it and how it happened. Give me a cohesive idea of how this happened. When we know there's no evidence that John O'Keefe ever got into the home of 34 Fairview. And there's no evidence he was thrown out on the lawn of 34 Fairview. There would have been blood, some evidence of it. There's nothing. No evidence at all that he ever moved. His phone says he didn't move. So, yeah, it's kind of like, isn't that weird defense? And as far as a mirrored video, if you look in yourself in the mirror every day, does that mean it's not a fair representation of you? You think you look different than what you look like in the mirror? It's just right is left and left is right. It's not a conspiracy. Jersey girl Elisa says, you do know that isn't the defense's responsibility to prove not guilty. And one more thing, Jeffrey, as far as it's up to a jury, hasn't even gone to a jury yet. We haven't even started opening statements. And I'm not a part of the jury. I'm allowed to have an opinion. So, yeah, it hasn't gone to the jury yet. It went to the jury once, and we got a hung jury. So, trying again. Jersey girl Elisa says, you do know that it isn't the defense's responsibility to prove not guilty. Well, it's their responsibility to argue that their client is not guilty if that's the plea. Even if the search was done later, the prosecution has to prove beyond a reasonable doubt. Even if the search was done later, the prosecution has to prove beyond a reasonable doubt. The defense doesn't have to show who else was responsible. No. But I think as far as putting holes in the state's case, I think they did a poor job the first trial. It was a lot of deflection and pointing elsewhere, and not a lot of really putting holes in the state's case. And what they did do was they went beyond the rules of their profession, which is they thought up things, leaked it to Turtle Boy, and had him write it, and then they referred to it in their own motions as it's been reported. You can't do that. They're absolutely need to, their job is to give Karen Read a vigorous defense, but their job is not to go beyond the rules of their profession and to make claims that are totally unsupported and fantasy. What really support? They just don't have any evidence to support their claims. Let's look at, I'm going to be talking more with defense attorney David McKenzie on Saturday about this. Let's take a little clip of my interview I did with him previously, where he's talking about what he did for his client Julius Jones in court and the difference between what these Innocence Project lawyers did for Julius Jones. Take a listen.
Her and getting her to admit that was a sprout of hair. Have they ever brought that up? No, hell no, they haven't brought it up. You know, which is wildly ineffective because that's the best thing they have. Now,
he's talking about a cross-examination he did in Julius Jones's trial where he got the eyewitness. She was saying his hair stuck out a little bit from his stocking cap, and David McKenzie exploited her language to try to make it mean something that she didn't mean at the time, but that he had longer hair than he did because his hair was actually very short. She said it was just sticking out a little bit, 2 inches, under the cap. You could see hair, but she didn't mean that his hair was 2 inches long, and he exploited that. And that's something you can do as a defense attorney.
That have been a fray from the stocking cap or something like that, maybe. I mean, I don't know. But you take what you have when you're a criminal defense lawyer and you cross-examine and you exploit things people say. And she said those things. And I can't believe they haven't brought that up. I cannot believe they haven't brought up a lot of other things with regard to his innocence. Instead, what they want to do is lie and conceal and just do horrible, unethical things. And it's not conducive to helping Julius. We got to rely upon the facts, what the witness said, that kind of stuff. And they seem to be unwilling to do that.
So if they said that you were a great lawyer, you did a great job with this case, and they still use the same talking points, would you still be giving interviews?
Yes. trying to help Julius out as best I can, given the fact that they lie. And it has nothing to do with me. Part of being a death penalty advocate is you fall on the sword. They're not helping me help him because they lie and they cheat and they steal.
Right. And so that was some of what he had to say. You can't lie, cheat, or steal as a defense attorney. And in my opinion, I believe that Karen Reed's lawyers are crossing the bounds of their profession. And this is something that we see more often than not in defense attorneys. Starting a witness harassment campaign. Doing a innocence fraud campaign so that it would never go to court. Really good lawyers don't need to do this kind of stuff. Resort to what I would consider fraudulent tactics. That's what do I have more? Let me just take a break. I think I have do I have more things I wanted to share with you for today? I think that's it. But I will be back Saturday. Don't miss my Saturday show with David McKenzie. It's going to be fascinating discussion, as it always is with David McKenzie. Don't miss it. I'll see you all Saturday. Have a great night and a great Friday, everyone. I'm off tomorrow. See you Saturday at 6.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mom. My innocence fraud campaign is my biggest hit yet. I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my son.